Resolution of the fact in issue, admissibility of the evidence. So usually for evidence to be admissible, it must be relevant to the case. But in certain circumstances, court could negate this scenario and reject the evidence which is relevant to the case on the ground that it was taken in an inappropriate manner with the prejudice to the defense, and if it is given the due weightage in the court of law, the fairness of the case shall be deprived. A journalist, historian can look at any source in order to build up a picture of what happened. A court applying the rules of evidence will exercise a much greater control over what evidence it will hear. Court has the power to know to hear the evidence in all scenarios. It could reject the evidence and it could accept the evidence. It's only the prerogative of the court. It can refuse to hear evidence which is relevant to the fact in issue on the ground that such evidence is inadmissible. So the court could reject the evidence which is otherwise relevant but is inadmissible because it was taken without following the due procedure of the law. There are different rules as to the admissibility in civil and criminal cases. Broadly, there are few restrictions on allowing certain types of evidence to be presented to civil court, for example, hearsay evidence. The difference stems largely from historic use of juries in criminal cases. So in criminal cases, jury is used, and in civil cases, jury is not used. In criminal cases, especially in the Crown Court, the tribunal of act is jury. So, the desire to protect vulnerable defendants facing criminal charges from the possible prejudice, irrationality, and inexperience of the jurors, that is why the court sometimes reject the evidence in the ground of inadmissibility, so that the court remains fair to the both parties and justice shall be done in an microcosmic manner.